in this fashion.
No, Milord, Milord, I'll say the 14.1 has to be considered. Why, Milord? I say, Milord, it starts with one will kindly come to the impugned order dated 21st of September 2024.
But your
Milord,
challenge
it says
7.2 is also there here.
also there. Milord, the order 7.2 order, the court goes to record there is no provision under the Tenancy Act, West Bengal Tenancy Act, to discover the landlord-tenant relationship. That is there.
All judgments are with you. You are ready with everything.
Judgments I do not
Only
have.
or you want to come only for admission?
But I'll like to come for admission, my lord. No, my lord will
Mr.
consider.
Chatterjee, then I'll call upon Mr. Chatterjee. Mr. Chatterjee, then this is an issue I will hear out.
There's, in my respectful submission, there's no question of any. If he's my learned friend is praying for a stay, my lord, there's no question of a stay. I'll tell you, Lordship, why. My lord,
no, that will come later. Stay or no stay. I want to know from you two things, two important things. I want to clarify this. One, that an order passed under section 7.2 will be binding for all time to come between the parties.
No.
Why?
I'll tell you, Lordship.
Why? No, because on the basis of an order passed under section 7.2, section 7.3 comes into play.
Yes.
Now, where defense is struck off, what remains?
If defense is struck off, my lord, he only has a right, my lord, to cross-examine.
On the notice?
On the notice,
Nothing more?
also. He can no, not on my my witness, my lord, can always be cross-examined by him.
He can't put his suggestion.
He can do.
How? Where is his case?
On
my
case.
little understanding.
On my case, not his case.
Correct. So what do you give suggestion? Suggestion is your case will be he will be testing you out, veracity. Name try to demolish. And his case he will suggest to you. Unless he suggests his case, he cannot establish his case. He has no case, question of suggestion does not arise. So it becomes very difficult.
No, 7.3 below is a consequence. First of all, whether he goes past 7.1 and 7.2. The first hurdle is 7.1. Admittedly, my lord, if I'm not mistaken, 7.1 was not at the hurt 2.
A very short point. I'll hear you fix it up. Tell me when.
Whenever you lordship. Whenever. I have no problem.
এই 29 তারিখে ওটা ফাঁকা আছে দেখছিলে না? বলছিল না 29 তারিখে ওদের হলো না, মিস্টার চ্যাটার্জির হলো না? 29th?
ভালো।
Because the next date is 19th, so 29th is fine.
Next date is?
19th February.
Challenging the order. No, Mr. Chatterjee. Down little bit. And difficulty you are facing because if you have 10 minutes, 5 minutes is being taken away by the judge. So that's another difficulty.
So it's always
I don't know. But
I
talkative judges are not
no,
very
it's a
helpful.
pleasure, I tell your lordship. Because we are always on some sort of a tension somewhere, my lord. I was telling this to Orijit Banerjee, my lord, always a pleasure before your lordship. My lord,
Absolutely.
a laughing assassin.
He's taking criminal matters now? No. He's taking criminal matters?
Criminal matters. So he was here, my lord, we had a so his lordship was, I told his lordship that whatever you do, we are smilingly going out. It's always better that always.
Always,
Put
always.
me to the sword, but do it smiling.
Yes. Call the next matter.
Yeah, good.
Matter number 13. 13 and 14, my lord, I read to have the petitioner. Very unfortunate judgment, my lord. My lord, suit for revision of a licensee. 13 and 14, self-same matter, my lord. Similar questions involved. Suit for revision of a licensee.
Why is upgraded? Why is upgraded? First tell me.
My lord, reach is to be issued. Position has been, my lord, police has already issued a letter fixing a day for rendering police assistance to the bailey.
When?
My lord, I in the
You are
next-
moving the matter. You will not deposit occupational charges. Very well. I am very happy that police has proceeded, but it ought to have proceeded earlier.
I'm telling.
Will you deposit occupational charges?
My lord, I may be about only 2 minutes time. Eviction of licensee. Notice of summons, it was not properly served. Register for order for Rule 20. Suitor give the ex party. Thereafter, they put the decree into execution. The application order and Rule 13. Well, kindly turn to page 15 and page 15 and study. My learned friends clients moved revision application against the order earlier when the 913 application was filed. Page 15. 913 application was filed under trial court considering the indigent person Riskowala. Indigent person directed the judgment judge to deposit one-time payment of rupees 10,000 as a security deposit. My learned friends challenged that order.
You will continue to occupy the property. You will not pay.
No, Justice Soprasati was pleased to direct, and 930 should be disposed of within two months. So
Not been done. I will ensure that that is disposed of.
disposed.
But you pay the occupational charges.
No. I prefer an appeal. I prefer an appeal against that judgment.
With judgment.
Against the judgment passed by the learned court of appeal below. Only one line order. Well, kindly say the nature of the order.
Prefer an appeal from which order?
My lord,
Which
order by which his
10th January 2024. 10 January 2024, page 37. That's
rejected?
There 913 was rejected.
930 rejected, appeal preferred. Well, kindly turn to page 37. Court of appeal below, my lord, while admitting of the miscellaneous appeal. Appeal was admitted, but the one line order, miscase be state till dispose of the instant misappeal subject to payment of 10,000.
Where is the division bench order?
Well,
Not
page
division
50,
bench. Where is
page
the
50.
order dismissing your application or order 9 rule 13?
Not annexed.
My lord, I have not annexed that, my lord. I have not annexed that. That is a judgment. My lord, I can produce it, my lord. My lord, a certificate copy has been prepared before the.
Show me the order, sir. I have asked you for a certificate copy. It has to be filed before the appellate court, first appellate court.
Same judgment, but one judgment I am.
ও দরকার নেই, ওটা দাও না। Detailed judgment has been passed. Very well. So after a detailed judgment has been passed, you have challenged this.
Appeal has been admitted.
Correct.
Appeal has been admitted, directing my learned friends clients to appear before the first appellate court below. My lord, by the order impugned, my lord, kindly see the order.
Which is the order impugned? 4th of April.
20th January 2024.
Yes.
Heard petition, heard objection. There is decision of honorable court referred to by both the parties considered. The
I'll direct the court, appellate court to decide on the occupational charges for the time you pay this, which shall be adjusted.
Well, kindly,
I will leave the property.
well, Justice Soposachi, but kindly see the
That is
observation. Page 15,
oversight.
my lord. This scholar
Now he has
indigent persons order passed with the landed trial court was not interfered with by Justice Soposachi, but very poor persons cannot.
good person will not help, sir. Please understand.
90 square feet of tile set room. 90 square feet.
Where?
Baranagar. 90 square feet. Kindly see the copy of the plan. 90 square feet tile set room.
90 square feet.
Kindly see this copy of
Here
the
the room is very.
that is schedule of the plane.
No,
90
print
square
the 90 square feet.
90 square feet.
Blood the-
Well,
19
kindly see last size of the schedule of the plane.
But this is very at lucrative place, blood. Boranagar and the Kolkata.
Back side of the building. There is a
Very well. So pay 5,000 per month, and the court will decide the occupational charges.
Blood the kindly direct my landed friend to pay the occupational charge as your lordship deem fit and proper from the date of decree.
Absolutely.
Yes, blood.
Absolutely. That's a law.
Yes, blood. And in default, blood there shall
Well,
be the
then,
another
well,
blood.
well,
In default, this blood the stay shall be vacated.
No, listen what order I will pass. I will direct for the time being on ad hoc basis to pay 5,000 per month from the date of the decree.
expertly decree, my friend. Expertly decree.
Please, can you hear or you will not permit me to? I'll not discuss. I'll pass the order.
Well, I have to.
Please hear.
The real picture, man.
Please hear. There has been no decision, adjudication, what should be the current occupational charges. The learned court will determine the occupational charges on the basis of materials available. And thereafter, the appeal will proceed.
Appeal may be jarred within 2 months. Appeal may be disposed of within 2
Oh,
months.
no, sir. Unless you pay the entire occupational charges, appeal will not proceed.
Expertly decree. Summons was not served upon the petitioner. Summons was not served upon the petitioner.
Challenging
My lord,
No.
my lord, item number 15, my lord, next matter, my lord, let it be 3 p.m., my lord. My fixed matter is at 2 p.m., my lord, before court number 17, my lord. The
No,
next matter, my lord,
I-
I'm waiting for it.
Lord,
At
next-
3 p.m., my lord.
If you want a not today, I'll give you a not today, Mr. Odhikari.
Huh?
If you want a not today, I'll give you a not today.
All
But
right.
my lord,
Next
this
matter,
is my
next
bad
matter
luck.
is-
next matter,
One side.
Having-
both the matters
Next
one
matter
side.
is the same matter.
In view of the order passed in such and
My
such,
lord.
the above divisional application also stands disposed.
It is by chance, and that is
Item number 15, my lord, I am playing for.
Notice. But we have given notice, they have received the notice.
Mention in the morning. Can't do it now. If they were there, I can take it up. If they are not there, mention tomorrow.
My lord, item number,
Yes, call the next matter.
matter, I don't know.
Don't mention now. This is not the mentioning time. Why are you mentioning? Yes.
My lord, item number 15, my lord, I am playing for short pass over, my lord.
15. Appearing on behalf of the Punjab National
My
Bank.
lord, in this matter, my lord, Mr. Vijay Adhikari, my lord, not kindly pass short pass over, my lord.
My lord, I have,
What is your instruction?
my lord, I have taken instruction that the bank authority, as per the notice dated, my lord,
Tell me one clear thing, sir. Please understand.
as per
Yes, I have my orders. I record everything.
No, sir.
In the order, it Mr. Bandyopadhyay, you are appearing for Punjab National Bank.
Fine.
I have recorded your submission.
my lord.
Yes, my lord.
I have given one privacy finding that
My lord, before,
this certificate has been issued prior to taking over possession.
Yes, my lord. No, sir.
as per my instruction, the only sale certificate has been issued.
How can it be issued?
Yes. My lord, as per section 13(2), well, kindly double to come.
এরা সিকিউরিটেশন এক দাও
My lord, I will.
ও ফেরত দিয়ে দাও সিকিউরিটেশন এক দাও সিকিউরিটেশন এক yes yes sir
Your lordship, kindly double to turn. 13. My
that matter was taken up on 17th. It has been fixed today only to give you an opportunity to take instructions. You remember?
Appropriate.
I recorded that also in the order.
Appropriate.
Hey, why are you making submissions, sir?
No, sir.
I will adjourn this matter for 6 weeks.
No, my lord. No, sir. Sorry.
You can't do this.
No,
It is an upgraded motion. If I am going to accommodate you, I have to accommodate everybody. Please understand the situation.
No, sir.
Yes.
according to instruction, bank has issued a sale certificate notice.
Under which provision?
13.
Sale certificate under which provision?
13 and 7 and 8 of the
Under section 13.
13.
Show me.
Where kindly 2, my lord. Subsection 2, my lord. Where what is that? Where any borrower who is under liability to secure creditor under a security agreement makes any default in repayment of secured debt or any installment thereof, and his account in respect of such debt is classified by secured creditor as non-performing asset, then the secured creditor may require the borrower by notice in writing discharge in full his liability to the secured creditor within 60 days from the date of notice, failing which the secured creditor shall entitled to exercise all or any of the rights under subsection 4. But in this regard, we have already.
Now come to 4.
Fine.
So why are you wasting time? 13(2) only gives you the right.
4. In case of borrower fails to discharge his liability in full within period of specified in subsection 2, the secured creditor may take recourse to one or more of the following measures to recover his secured debt, namely, take possession of the secured asset of the borrower, including the right to transfer by way of lease, assignment, or sale.
Sir, can you issue a sale certificate
Yes,
without taking possession?
Yes.
Show me.
Page paragraph 37, mine. May I permit it to read, mine?
Yes.
Paragraph 37. The other important aspect discriminable from V. Nobel Kumar to before not laid down either by Apex Court or any other High Court is realizing to right to action approach the tribunal under section 17. It has been held that an appeal under section 17 is available to the borrower only after losing possession of secured asset.
Sir, you read the entire portion, not relevant for this. Relevant part, sir.
In this matter, my lord, the auction purchaser have filed this writ petition against the Central Bank of
I
India.
not forget it. Read, there is no warrant for reading the word possession in section 13(4)(a) of the SARFAESI Act as restricted manner so as to connote physical possession only. Rule 8.3 of the SARFAESI rules is a provision which ordains that what should be duty of an authorized officer. Correct?
Yes,
Now, have you read the order? Wait, now have you read the order under section 14?
I have applied for.
Have you read the order under section
I
14?
have applied for section 14.
Allowed. Arey, what is this?
Has been pending, my lord.
Kindly come to the orders under section 14. On 19th. On 19th.
Page 18, my lord.
Page 18 of the can. Yes. A direction has been issued to facilitate you to take over position. Admittedly, no position has been taken over. As on 19th, therefore.
Yes.
How could you issue sale certificate, Pratt? Small question, answer.
I will take the as per the symbolic position is concerned. my lord.
Where did you take symbolic position? Where is your taking over symbolic position? Show me.
Yes.
So on the basis of symbolic position, you issued the sale certificate. And the tribunal will not hear his application and keep it pending. Not here. You will take it, execute it, finish off the matter. Then what is the object? Sir, what is the object of section 17?
He has to file the appeal before the date.
He has filed it.
Yes, I have no
And matter is pending.
direction to the tribunal to expedite the matter. I have no issue, my lord.
I'll grant the stay. I will grant the stay. Take instructions, come back. I'll grant stay and direct the tribunal to consider his case.
My lord, kindly see the
I
judgment.
take I've read.
Kindly see the judgment, my lord. Otherwise, I
You
will
did not complete the judgment.
Yes, yes, my lord. Kindly
Place
come
it.
to the last page, my lord.
Yes.
The question, paragraph 38. The questioner thus the answered by holding that the respondent do not owe a duty. Respondent means the bank to hand over the vacant and peaceful.
Sorry, you cannot show me that you have taken any sort of position. Neither.
I have paper. I have piece of paper.
Where?
Right?
Show me.
Yes, yes. More of the
It is still in your pocket, Mr. Bandyopadhyay.
I'll give you. এখানে আছে
Don't hand over a bunch of papers to me. Hand over the particular paper by which possession was taken. Don't give me pictures. Pictures will not do. Possession is not taken by pictures. Possession is not taken by pictures. Either there has to be minutes or an order taking over possession. Someone has to be there. You know how symbolic possession is taken?
officer is there, my lord.
Picture will say.
Yes, ma'am.
Sir, there is there is a language. Sir, there is a language in Egypt. By of reading the picture, sir. I do not know how to read it. Sir, someone has to file an affidavit to say so. Who is saying? Who has come forward before this court to say so? I do not know the language of pictures. That is my difficulty. So therefore, to assist the court,
Yes, my lord.
someone has to file an affidavit. So instead of going there, what I will do, correctly, sir, as you indicated, take instructions, come back. I'll place this matter next week. Take instructions, sir. In this matter. In the matter, then I will, if you file affidavit in opposition, then I will hear of the matter. Choice is yours. Or if you want me to send it back, then I will send it back. Take instructions. Because you are for the bank, you cannot decide on your own.
Yes, my
You
lord.
take someone from, take assistance from any of your officers, ask your officers to come. So that otherwise you will find it difficult for yourself.
I'll file status report.
I am not directed you to file any status report. Your status report I will not go through because any other document I will not hear it. You are showing me a picture to demonstrate possession. I am not recording that. It is unfortunate that you show me as an advocate pictures. Your client says that here are the pictures of taking over possession and show it to me. You are an advocate, sir. You ought to have considered.
Annex this document. I'll file a report.
You have to file it. I'm not calling upon you. Take instructions. Or else, if you want to file an affidavit, Then I have to admit the revisional application, direct exchange of evidence.
This is not in prayer. I mean, original prayer. Kindly see this is original prayer, my lord.
I don't know.
Only prayer for experience. Only.
I have recorded your submission on the last occasion. That is recorded in the order.
How many submissions?
No. You want to file affidavit? Very well.
Not to stay, my lord.
Continue. Stay is already there. It will continue till disposal of the revisional application in that case. Take up your mind. I will send it back to the tribunal. But for that, you have to take instructions from your client. You cannot decide on your own. I will give him the limited protection. The tribunal will decide this issue,
Yes.
whether this could have been done or not, and decide the matter.
Yes.
Take instructions, come back. I place it on Monday. That will inure to your benefit also.
Yes.
And I cannot read those pictures. Sir, your clients tells you that pictures will demonstrate service. You do not put a question to yourself.
The opportunity.
No, you do not put a question to yourself. Will a picture establish taking our position in a court of law?
Yes, fine.
You ought to have put a question to your client. And sir, you are saying something. How will I go and make the submission in court tomorrow? What will the court ask me? These are pictures, and by the pictures you have taken position. There is no document, nothing. Please understand. You are my officer.
Yes.
Before making a submission, take instructions, come back. I'm just adjourning the matter. Yes, Mr. Odhikari, I'll send the matter back. Yes, I'll send the matter back.
And my lord, with the
Nothing.
my lord,
Nothing more.
my lord, one thing.
Nothing more.
My lord,
Mr.
one
Bandyopadhyay,
submission, I am ready to pay the entire amount of
I will not go there.
25
Who will say before this one?
Yes, my lord. That may be recorded. That
No,
I
I will not.
am ready with the money.
You
that may
give
be-
them the money. You go and give them money. Don't hand over.
My
to
lord. No, that I am not saying.
Don't
At
hand
least-
over to me,
No,
Mr.
no,
Bandyopadhyay.
no, my lord, I am ready.
Mr. Odhikari.
It is true. But my lord, they are not safe.
Unless
But your
you want to
lordship
give
is
that,
safe.
given charity to the court, that is different. Then I'll ask your client.
Your lordship is very safe, but the bank is not safe.
I
That
do
your
not
lordship
know.
could understand. But my lord, at least I am ready to pay
Mr.
the entire
Bandyopadhyay,
amount.
learned advocate, would submit that.
Entire amount
Mr.
of
Bandyopadhyay, learned
25,
advocate,
26 lakhs.
prays for an accommodation to take appropriate instructions in the matter. I'm very clear. I do not want to retain this matter on the file. What will you file affidavit here? The first court is there. Why you want to lose a forum? You go and make the learned tribunal understand your facts. Apropos their application, let them succeed first. Here you have to answer. There they have to answer. So it is better they go there. Let them establish their case, whichever way. I will send the matter back. And till that, I'll give them the protection for another, say another 2 weeks. Or another week till the next day before the trial court.
I will suffer great loss. My client not to file. I will suffer great loss.
Then I'll send it today. Do you have instructions?
Yes, you can.
Do you have instructions?
I have oral instructions.
No, oral. You are a bank. Mr. Bandyopadhyay, later on you'll file.
Bank has already issued the sale certificate, but sale deed has not been completed.
No further steps. I've said so. I have not asked you to reverse it.
Humble submission before Lordship to kindly send back the matter for the tribunal and for expeditious hearing, my lord. I have no issue, my lord.
With that's very well. Then I will, with that protection, I'll send it. Make up your mind.
How long, my lord?
Till the next date before the trial, before the. Dakho. There, Mr. Esho.
My lord, even if.
We have nothing more. Nothing more.
Till the next date. And they, my lord, my lord, the tribunal's act and conduct. My lord, imagine the situation. My lord, one thing, I'm ready to hear out it, what they will say. My lord, that they, but if they will not till the, my lord, till the disposal, my lord, at the earliest possible. My lord, till the next date, my lord, whether I'm in trouble or not.
Hear me.
Protection for the next date.
If you lose
No,
confidence,
for the next date.
if you do lose confidence,
The tribunal means rather who is not hearing me, who is throwing me out, and my lord, the self certificate. They are taking symbolic poison, they are taking physical poison. Page 16.
on
My lord,
17th do it. Do not take any steps. I'm just going through the law on the subject. Check out. Yes, yes. Mr. Adhikari,
Yes, my lord. I'm grateful to your lordship.
come with judgments to assist the court on that date.
My lord, if the rule is very much clear.
Come with judgments to assist the court. You don't want to come with judgments.
Judgment.
Forget his judgment. You come
Yes,
with your
yes.
authorities, anything.
Yes, yes.
Yes, call the next
Then there
matter.
will be, judge copy দাও। Judgment copy, my lord, that what judgment they are producing, let a copy be given, or at least a reference be given. Reference to দিয়ে দিন।
Your Lordship, I was here last week and you made certain observations regarding visitation, very succinct, and it has been very gratified. We are very gratified about the visitation, Your Lordship. I am for the mother and the petitioner. It has been other party. Nobody is appearing. It has been already about 15 days ago. We had already sent the revision application once, but on your order, we sent again, Your Lordship, but they are not appearing. I am for the petitioner, mother and wife, and she is here. Beg your pardon? The child is not here. She has just come back from the school. She is at home. Yeah, she's with the mother and she's the natural guardian for the last 3 years. The mother is having just in custody of the child. And she is organizing everything, schooling, her dress, her food. The order is very simple, Your Lordship. The visitation, they say, the lawyer has to accompany the respondent's lawyer has to accompany the during the visitation. That is the one part which my client has objected to, because there is no need. They will not in any way enhance the value of the visitation at all. Let the this thing OP come. We have no objection. The way you want, in the manner you want, in the frequency you want, Your Lordship. There is no hassle. It's going to be 4 now on the 9th of February. Your Lordship, earlier also in the page 81 of this petition, no, they have not made any visitation in the last 3 years, Your Lordship. They have not made any application, no visitation, no communication, nothing. But notwithstanding that, you gave only one, Your Lordship. That was on this 11th of November 2023 was the only visitation. No, there has been no visitation, Your Lordship. Only once they came with the lawyers, and which we objected, but that they wanted to come. They did not come. They wanted to come, and they sent a message that we will be accompanied by our lawyers, which we said. That is not a visitation, Your Lordship. There's only a message. There has been no visitation at all. But we have no objection to that. Your Lordship, you are very succinct. That has already been done, Your Lordship. Sir, you see page 81 of the order, Your Lordship. It says very clear, Your Lordship, who will visit, Your Lordship? The other party should visit. Here the child and mother are willing to. No, how can it is just adjoining Alipur police station, Your Lordship? It can't be in an urban. Yeah. There is no need at all, Your Lordship. Let them. Why perceived threat, Your Lordship? Can a perceived? Why should there be a perceived threat in absence of a attempt? I give you a guarantee, Your Lordship. Let the OP visit. I stand before you to give a guarantee that there will be no threat at all. In the last 3 years? Yes, we have, Your Lordship. No, not this court, Your Lordship. But there is already somewhere going on, therefore we didn't. Okay. Okay. It was served, yeah, very close by. Gratefully, Your Lordship.
I'm appearing for the appellate, madam. Lord, on the last day, on 17 January, matter came up before your lordship. Lordship directed me for to take instructions from my. The matter is for setting aside impugned order dated 15th January 2024 regarding maintenance to the wife. And our prayer is that said maintenance was 50% of the net income, whereas lying on the Honorable Supreme Court judgment. Yes, my lord. But we complied with that order, we filed this petition for stay of that order. An interim order was passed on 19th April 2024 for 2nd April 2024 directing us to pay 20,000 per month toward maintenance and 25,000 for toward areas of the maintenance. We have complied the honorable court's order and have till date paid 4,50,000. Now, in the meanwhile, salary has increased, my lord, and I'm suffering, my lord. In this meanwhile, wife, we are provided, my lord, only one humble request. I am suffering. Maybe I'm a man, maybe I'm a husband, but men also suffer, my lord. The 498 case was filed. In the this honorable court has been pleased to quash the 498 on frivolous ground. Men also suffer. Where will the suffering of men will go, my lord? He married out of bona fide this woman. No, my lord. We both suffer. We both suffer. The factual case should be taken. My lord, my humble litigation is going on. We want to. 498 is quashed. My lord. And that is quashed, is proven to be quashed. That was filed. My suffering, my mother has to go in ambulance and take bail. After that, can any relationship survive? I wanted to have a golden handshake. I want to pay one permanent alimony, but she don't want to release me. Yeah,
My lord, on the last occasion, my lord was to observe as far to comply the order of the trial court regarding maintenance. They no, my lord. No, my lord. That order was not complied. He complied, then she prayed, then another prayer was that on the last occasion that mat should
Whether or not even pay the entire, whatever it is, that was the understanding.
Well, I have the instruction today, my lord. He did. She did not. He did not comply the trial court order, my lord.
no, against the trial court, there's a stay.
My lord, this was the observation submitted before your lordship that.
But they didn't stay. They didn't comply. I will direct her to comply.
Yes, my lord. That was.
I can settle and want to ascertain on you.
My lord, they will not settle. They will contest the matter.
I see.
And Mala 2018, I got married. He left me for with other persons. She went. She left me. She deserted me. She went out of the house. She filed 498. My lord, because since my salary, I am. This is a payment summary. My lord, my lord, my lord. My lord, I paid a made a.
The senior bank manager of
My lord, and he is handicapped to 45%. My lord made a payment summary as my lord directed on
skills as disposal of the suit, monthly maintenance.
That is already there.
I'll provide that in case she does not the suit will not.
We will pay, my lord. We will pay. We are ready to pay. We are ready. Petitioner is suffering, my lord, so much. He wants to pay everything and get relief. He wants to get relief. We will maintain. It is a statutory right. We will pay. With no other option. But should be considering my pain also.
I am not from the very first day I am paying a lordship to that is from the court below. Yes, ma'am.
But fine.
Here, I'm not saying this would this picture and passing on. It will give you a picture and no day. That situation will become better for her.
It is true. It is true. The logic.
And passage of time, needed the petitioner fee. It is better to approach the court and pay off everything.
He want to actually pay. There was a provision of golden handshake. At that time, his net income was, my lord, his net.
Prayer never object, my lord. I am always.
There, passing the court.
Yes,
It is happening in lower court, in a high.
always, my lord, it apply your lordship action and also personal objection as a man of the citizen of the country. Want to help you. But she is saying, don't I want to say? But, my lord, I now don't want to say anything. But she said, but he is a senior branch manager
So what?
of bank.
How does it?
And
Is
her
that
father is getting pension. Don't suppress it. No, my
there is
lord.
no point. There is Supreme Court judgments of reasonable expenses and net salary 25. He is absolutely wrong.
No, my lord.
You can hear the matter then on point.
Grateful.
Then hear the matter on merits. Grateful, my lord. Deeply obliged, my lord.
I don't know. My
Lordship, the advocate on record, Sanjay Mukherjee, is currently in the hospital, Your Lordship. Kindly make it not today. Grateful, Your Lordship.
At least 121.
But I am challenging the order just fast by the High Court. When I rejected my application, the order which was passed by the trial judge on the basis of the application 31st May 2017, page 53 man. I made an application order 1 book. That application was rejected. That day, your lordship asked me a judgment letter. I may be permitted to add as a judgment letter. But one thing, my lord, your lordship can dispose of the matter with the liberty to make an application before the court below, order 21, rule 99, 100 or 101. Then, my lord, whole purpose will be served because I have in possession. I am in possession. The digital property, I am. Yes, my lord. No, your lordship can dispose of the matter with the liberty. Then your lordship dispose of the matter. Monday. Ghosh means Gopal Ghosh. No, Mr. Ghosh. On Monday.
My civil divisional application, my lord. But before I place my case, my lord, I'll apologize for yesterday. Was appearing, my lord, possibly in the wrong way, my lord, virtually. My lord, my civil divisional application, very brief facts. Lordship needn't be troubled with the papers. I'll just indicate the facts. There's a suit for eviction that is instituted against me. I was the tenant under the West Bengal Premises Tenancy Act for reasonable requirement, my lord. The suit, my lord, did not disclose the exact measurements of the property. I'll file my written statement in the suit. Measurements, again, I do not disclose. But during the pendency of the suit, my lord, there's a commission that takes place, advocate commissioner, whereby a commissioner files a report. The measurements of the property are disclosed in the commissioner's report for the first time. Decree of eviction passed against me. I go prefer a first appeal against that. There's an application, my lord, for stay of the decree, in which there's a direction for occupational charges. I am not shying away from paying the occupational charges. When my application for stay was being heard, my lord, it was recorded by the learned first appellate court that the total measurement of the property is 250 square feet, which is contrary to the commissioner's report, because the commissioner's report disclosed that it's 175 square feet. Be that as it may, my application for stay also does not disclose the measurement. They file a written opposition. The plaintiff respondents in the first appeal prefer.
Mullah, if you want to resist, order 21, rule 99 to 100. Yes. Yes, I know. Yes. Yes, sir. Yes, ma'am. Mullah, what is the item?
I will not give the liberty. Liberty is not the same. No. Monday, the matter will be there on Monday. Yes. I will. Yes. If you ask somebody else not to tell, you will go now. Monday. You are taking like this. But if the order, I cannot say what it is you have. No. I am saying to give the liberty. I will not. I cannot. That is why I have got.
Yes. Yes.
Lord, may I just recapitulate, my lord? Yes. Yes.
So therefore,
No. He hasn't, my lord. He hasn't. So I'll indicate before, when my stay application was being heard, the court says that it's 250 square feet based on the submission made by the plaintiff respondent. Yes. Commissioners that the total measurement of the property is 175 square feet. There is no dispute that is raised. There is no. I'm agreeing to that. In fact, they have not preferred any challenge to that. They have not filed any exception to that report. They have never denied that. In the first appellate court, there's a review also that happens, my lord. Lordship will bear with me for one more minute, my lord, because there are various counts on which my application, there's a direction that's been passed. My recalling has been dismissed. Actually, my application for modification has been dismissed, my lord. I am challenging, my lord, the impugned order dated 7. No. Not modification. It's in the nature of a review application. Lordship bears with me for one moment. Lordship bears with me. I understand. Both, my lord. I would necessarily. In fact, actually, the order passed in the review application. The last, my lord. No, parent order, my lord, there's no certified copy. I have challenged the last order, page number 64, 18th of November 2000. No, this is the original order of stay that is passed.
That is page 64, wherein the court says that it's
Lordship, the in the present case, kindly Lordship see the order dated 17 January of 2024.
only the commissioner's report is there.
What is next page, Lordship? Yes. Then disclose the area of suit shop room as to
There's no measurement here. I'll create the page number. No, I'm sorry, my lord. It's page 14 of my application.
tomorrow.
Other
And I'm not caveated.
We've not served them, my lord. We've not served. We've not served. My application is not admitted. I can't be put to a disadvantage because of that. Yes, yes. No, no, absolutely. I'm bound now. Yes, yes. Yes, yes.
Execution is suffered loss, execution is
This is the appeal. There is a stay of the execution of the decree.
175 or 2550 kind of.
Nayak, Shashwat Nayak, my lord.
I'm extremely grateful, Your Lordship.
For the petition. My Lord, in this matter, it's a very simple case. One ejectment suit has been filed against me. One ejectment suit has been filed against me on 26. Shall I? One ejectment suit has been filed against me on 26/3/2018. On the first date of appearance as defendant over here, being the petitioner in this application, that is on 5/5/2018, I filed an application under Order 17, Rule 18 and prayed for rejection of the plaint. The learned court below given 15 adjournments to the respondents, only 7 except 3 for the COVID or 4 for the COVID. There is no caveat over here, Your Honor.
Lordship, actually,
Okay. The thing is that
yes,
so many adjournments. Then part hearing was made on 21/11/2011. Pardon my lord.
Order 7 rule.
That Order 7 Rule 11. My only point is that it should be heard at first prior to disposal of Adam. Grounds of the Order 7 Rule 11 is that I have stated over here that they have suppressed material facts and filed this ejectment suit. They have paid very less court. They have paid very small court fees, which does not comply with the suit property. And no, my lord, I have said that only thing that I asked before the court below, that let this petition under Order 7 Rule be heard at first, then you go for other proceedings. And at last on 21/1/23, they filed an application for withdrawal of the suit. Now, I have filed an application on 5/5/2018 Order 7 Rule, keeping. Now, the my thing is that withdrawal of the suit for filing a fresh suit against me with a fresh cause of action. Now, the thing is that same cause of action, withdrawal of the suit, I will be prejudiced. Well, my Order 7 Rule 11 was filed on 5/5/2018. Then there was no need of keeping in abeyance. The learned court would have concluded my application, either dismissed my application. Then why I was kept in abeyance for so many years? And after that, they come with an application for withdrawal of the suit to file a fresh application.
Lordship, I'm just, I've been instructed to say that.
Yes, withdraw.
My right will.
My right will be jeopardized. My lord, I am saying there is a building. Yes, formal defense. Now the thing is that
Nothing.
my lord, in the court below, ask them for clarification. Why you want to withdraw suit? No clarification is given at. They went for a state examination in chief, and now pressing me for cross examination. No clarification was provided. They have flouted the order of the court. My lord, let the learned court below dismiss my Order 7 Rule 11 if necessary and go for withdrawal of the suit.
Actually, my lord, we want to withdraw that.
Let my petition be disposed of.
Yes, it has been done.
No section has been given. Only 2-page application for withdrawal of the suit. Plain application, normal.
My suit, if I want to withdraw,
Nobody can stop him, no doubt.
One thing, my lord, I
But the
just
thing is that-
inform your lordship, he is holding a permissive possession. He has no right.
I won't go into the merits in this factor, madam.
That trespassers cannot be evicted without due process of law. Nowadays, it has been changed. Your lordship knows about it. Your lordship.
This thing would not come in this position, my lord. My thing is that
But, my
in
lord,
Dahiban's case,
holding a
in
permissive
Dahiban,
possession first, and second, it is my suit. It's my entitled whether I will withdraw. Whether
your suit you withdraw, I don't have any objection. But the thing is that why?
permissive possession means I have given my property, suppose to my friend, caretaker, or relative to stay.
My lord, they are
He has
bypassing
no
the
right.
matter.
Even, my lord, a plaint has been filed.
We are all inter-se relations. They have suppressed this fact.
I am the owner of the property. He is my relative. He is my relative. Just given him to stay. He is one of my relatives. He is one of my relatives.
Page 46, P3. Page 46, P3. I have the license.
My lord, see,
Personal relation, my lord.
my lord, I pray to see
I have just allowed him to stay.
P3, page 46 will speak out clearly. What is what?
P3.
I'm sorry.
Because I mean, just consider that you have to
My lord, not at all, my lord. The thing is that my only point is in Dahi Bank's case, in several cases, they have said whenever an order 711 is filed, that has supposed to dispose of first. So why keeping in abeyance order 711, they are going away? Then why I was kept in abeyance? Why I was kept in abeyance for the last 5 years?
Having problem that I cannot withdraw my.
No, not at all, not at all.
They are in the suit.
I am giving an undertaking before your lordship.
It has changed.
Let them withdraw. They are the
withdraw the
proprietor of
suit.
the suit.
What
They can do
problem?
whatever they like. But the thing is that my order 711 should be disposed of. Why I have kept in abeyance? Why the sword of Damocles was kept hanging upon me? Our key, again they say that I have to file an application under order. Yes, my lord. The thing is that also wrong orders in part. I have to serve copy under order 12 rule 10.2. Where is order 12 rule 10.2 in CPC to serve copy upon them after hearing a fragment portion of the order 7 rule 11? Then it was pass these orders. Total disarray. The lower court is totally disarrayed in yes, my lord. Let them stay in the meantime. My lord, it will be no, my lord. The thing is that until the order 7 rule 11 is disposed of, short period.
Last chance.
The High Court will proceed with the matter. Then what will happen in this court? This court will become infructuous then. I am not expecting. No. Of course, 100%, 200%. But the thing is, it should be done in a nice way, my lord. It should be done in a nice way, fair way, in equity. I am also pleased. I am a relation of his. I am not having enmity with him. Yes. And also I am having position in the property. My relations, 3%. My lord, my lord, just a fragment. 3%. 3% signed and give me position to enjoy the suit property.
Sir, our permissive rights will be prejudiced. For such reasons, we want Order 7 Rule 11 in merit. If they do not permit us Order 7 Rule 11 here, then our merit will merit will be lost.
No. Yes, my lord is correct. My lord, this much.
Our rights.
Let me say. No, yes. My lord, this much can be given. Let the Order 7 Rule be disposed of, then without petition be heard.
Yesterday, my lord asked me to produce the keys. This is record of rights. I can receive and
I'm grateful, my lord.
Tomorrow then? Yes. Next year also,
I'm grateful.
Your Lordship may be permitted to mention a matter for regional side.
You got the orders separately. Huh? Paying all the orders. Okay, just take out just the show mentions order. The show mentions order. Mention. Yes, 19 December. Before that, I want the 7th November order. Shubhashati for change. 7th November. 2nd November. Yes, sir, I have this. And before I proceed further, my Your Lordship remembers on the last occasion I was dealing with the opposition of my learned friends, primarily with regard to the preemption right. Because I say that he doesn't have any say. Sorry,
Yes, he doesn't have a say in this proceeding. Now, my lord, because voraciously, my lord, vociferously, rather. Voracious is for eating. But I'm feeling very hungry. That's my lord vociferously argued that there was an order which recognized the preemption rights of my learned friend's client. Now, my lord, may I show two orders, my lord? My lord remembers. No, my lord, these are orders, my lord, of this court. No, my lord, one is a part, another isn't. Yes, yes. My lord, this is, my lord, an appeal which 2nd November 2023. This is an appeal preferred by eyelid. When it notices the date, it's 2nd November 2023. Learned counsel of the appellant contends that during pendency of an application of the petitioner for a direction on the official liquidator to disclaim undivided half share of the concerned property at 46B, the official is proceeding with an e-auction sale which is scheduled to be held on 7th November. It is argued that unless the rights are achieved, the sale shall not go through. Should not go through, sorry. Now, my lord kindly takes the next page, the last paragraph. Keeping in view the balance of convenience and inconvenience of the parties, along with such and such a disposal with a request to the learned trial judge, such a convenience, take up the application bearing CA number. That's my application. Pending at the base of it, before the learned trial judge confirms the sale process to be held on 7th November. So basically, the tenant of this judgment or order is, my lord, my application should be heard of first. My lord, kindly, my lord, I have not disputed that, my lord. My dear lordship, my lord, I have not yet said anything which would, my lord, portray that my client is, my lord, not is complaining to your lordship, my lord. That it is not. My lord, why I am showing this, my lord? This was my appeal. So basically, before confirmation, I should be heard of. That's the basic tenet of this order. My lord, the next order I would like to show your lordship, my lord, which is Justice Showmanson's division bench of 19 December 2023. Oh, he's got a copy of the opposition. In the opposition. Now, my lord kindly sees